Vietnam remains one of Asia's most attractive destinations for foreign investment. But when disputes arise, especially unpaid invoices and commercial contracts, many foreign companies discover that debt recovery here feels different from what they are used to. It is legal, it is possible, but it requires a local playbook. In this video, we explain what makes Vietnam's debt recovery process unique, and how to use those realities to your advantage. 1. System structure, civil law with procedural discipline. Vietnam is a civil law jurisdiction. Statutes and procedural codes are the foundation for deciding cases. Vietnam also has published court precedents, which can support consistency in interpretation, but success usually depends less on arguing by precedent, and more on matching your facts to the right legal provisions, and meeting procedural standards. That is why experienced strategy focuses on building a clean legal narrative, and a compliant evidence file, not just strong arguments. 2. Procedure can decide outcomes. In Vietnam, outcomes are heavily influenced by procedural discipline. Choosing the correct court and jurisdiction, naming the correct legal entity, showing proper signing authority, and preparing compliant evidence often matter as much as the commercial merits. For foreign companies, small paperwork gaps can create delays, objections, or unnecessary procedural disputes. The advantage is clear. When your filings are precise, your case moves with fewer surprises. Legal discipline, clear submissions, verified evidence, and procedural timing becomes a real competitive edge. 3. Debtors understand the process, and some use it. Many debtors understand that delay can be leverage. Some will challenge evidence, request additional steps, change representatives, or raise counter issues to slow progress. In more serious situations, you may see avoidance behavior, such as restructuring or questionable asset movements, depending on the facts. Some tactics are lawful, others may be challenged if evidence supports it. This is why a debt recovery team must understand not only the law, but also the common behaviors that appear in disputes, and react with structured escalation rather than emotional negotiation. 4. Enforcement is a separate battle. Winning a judgment is not the end. In Vietnam, enforcement is handled through civil enforcement procedures, and it is not automatic. Creditors typically must submit an enforcement request, provide a complete dossier, and actively help identify attachable assets. Practical recovery often depends on early asset intelligence, where the debtor banks, what assets exist, and what can realistically be attached. The key takeaway is simple. You should plan for enforcement from day one, because a win on paper is not the same as cash collected. 5. Courts are accessible, but speed is not guaranteed. Vietnam's courts are accessible to foreign parties when jurisdiction and procedural requirements are satisfied. However, timelines are not always predictable. Delays may occur due to case volume, document disputes, procedural objections, or internal processing. That is why many companies consider a strategic mix: negotiation backed by formal legal positioning, arbitration where appropriate, or carefully staged litigation when the evidence and enforcement path are strong. 6. Language is legal, not just linguistic. Vietnamese is the primary working language in most proceedings. Foreign language documents often need Vietnamese translations, and certification or notarization may be required depending on the authority, the document type, and how the document will be used. This should never be treated as a cosmetic step. A poorly translated clause can change meaning, weaken a claim, or create avoidable delays. The safest approach is legal translation combined with legal review, so the Vietnamese text reflects both the business intent and an enforceable position. 7. Negotiation can work when backed by credible steps. One advantage in Vietnam is that structured legal pressure often leads to settlement. Many debtors ignore informal emails, but respond when they receive a professionally drafted demand letter with evidence references, a clear deadline, and a credible escalation roadmap. The skill is knowing how to escalate without immediately burning the relationship. Informal notice, formal demand, settlement drafting, and, only when needed, formal filings. When escalation is disciplined, negotiation often becomes faster and more realistic. We do not fight the system, we work with it. Our approach is practical. Evidence first, procedure-aware filings, and an enforcement-focused strategy. We help clients structure claims, choose the right forum, set deadlines that matter, and build recovery leverage early. From contract review to dispute escalation and post-judgment enforcement planning, we focus on one result: making the process work for the creditor, not the debtor. Vietnam's debt recovery process is unique, but absolutely winnable. If you apply foreign assumptions without adapting, you may lose time and leverage. But if you use a Vietnam-ready strategy, local legal intelligence with international standards, you can recover faster and more efficiently. If your business faces unpaid invoices or contract breaches in Vietnam, contact LTS Law for a strategic assessment at lts.com.vn. In this market, those who understand the system win it.